Okay, Laura, it's all yours.
All right. Hello, everyone. Thank you for your patience with me this evening. I went to the town offices thinking that this was a hybrid meeting, so I apologize for making you all wait. But we're here tonight to talk about the right to know law, and what a better way to start off the holiday season than to talk about ways that we can get ourselves in trouble, right? The right to know law, it's basically broken down into two sections. There's a section on meetings and there's a section on documents, and we're going to talk about them separately. But the most important thing to remember about the right to know law is that the court always looks at it in the framework of the preamble. And the preamble says, openness in the conduct of public business is essential to a democratic society. The purpose of this chapter is to ensure both the greatest possible public access to actions, discussions, and records of all public bodies and their accountability to the people. So when the court is interpreting the right to know law, it will always err on the side of disclosure. It will always err on the side of it being an open meeting. And it will always err on the side of sharing everything you can with the public, which is why, as a general rule, when you get right to know requests, unless something is clearly exempt from disclosure, I always encourage you to provide whatever documents are being requested. Some of them are going to be fine. Some of them are going to make the town look good. Some of them are going to make the town look not so good. But that's not a basis to withhold them. And so we always err on the side of disclosure. So let's start by talking about meetings, because that's what most of you, I think, deal with. It's really the administrative staff that deals with the documents part. And we'll start with the definitions portion of the statute. And that, actually, we're going to skip over that. We're going to go to 91A2, which talks about meetings. And it's a really long section, and it's very, very dense. There's a lot in there. So let's start with the basics. What is a meeting? A meeting occurs whenever a quorum of the board is in a situation where it can communicate contemporaneously about any matter that the board has jurisdiction, control, or supervision of, whether you intend that or not. So the easiest concept of a meeting is we're having a selectmen's meeting or a zoning board meeting or a planning board meeting, and that's been properly noticed and everyone shows up and we have our meeting and we keep our minutes and everything's nice and easy. That's the ideal way that a meeting should happen. It's very easy to accidentally slip into a meeting, and there's a couple ways where that becomes easy. The first is by email. And the right to know law has been amended over the years to make it very clear that if a quorum of the board is emailing each other about substantive matters over which the board has jurisdiction, that is a meeting. And unless the public is able to be part of that conversation, it's an illegal meeting. So this is why I always beat the drum about not emailing each other. If there is something that the majority of the board or all of the board needs to review, weigh in on, or discuss, it always encourages you to go through your administrator, whoever that might be. So if I'm on the zoning board and I have a question about an application that we received, and I want to know if other people have other materials beyond what I have, it's not appropriate for me to email my other board members. It is appropriate for me to email, for example, Naomi, and say, Naomi, could you email the other board members and ask them this question, and then relay the information to me? It seems like a distinction without a difference, but there's a real distinction there, because if Naomi is emailing everyone, there's no chance that someone's going to accidentally reply to all and start a conversation about whatever she's emailing about, right? Because she's going to blind copy everyone, and therefore you can't reply to all. And that is the safest way to have any sort of email conversation. Moreover, I would encourage you not to be even be having those kinds of email conversations about substance. Really, the only time I like to see email used by a board is for scheduling or for distribution of drafts. And that's really it. And that's just because it's so easy to accidentally start having a meeting. and start having an illegal meeting. So it's not a meeting if you run into each other in the grocery store, if you are all going to the town Christmas party, if you are all coming to a court hearing. Not a meeting. Until one of you says to the other, hey, that application that's on the agenda for next week, what do you think? And then a third person comes over and suddenly you have a quorum talking about a substantive matter. So we want to be very, very careful that that doesn't happen. Other things that are not meetings are if there's a collective bargaining agreement and you're having a negotiation session or a strategy session, that is not a meeting. Consultation with legal counsel is not a meeting. And you might hear us use the word non-meeting a lot, and it's only because there's no real term in the statute for something that's not a meeting. So the municipal bar many years ago just began calling it a non-meeting. So when I'm coming out to meet with a board about an application or an issue you're having, often I will get the question, well, how do we post this? Well, if it's just going to be me and the board and no decisions are going to be made, it's a non-meeting. So you don't need to post it. You don't need to let the public attend, and you don't need to keep minutes. There's an alternative way to have that consultation that we'll talk about when we get to non-public sessions, but that is generally speaking the way I prefer to do my legal consultations because you don't have to do those three things. Another thing that's not a meeting is circulation of draft documents, which when finalized are intended to only formalize decisions previously made in a meeting. This comes up more often than not in our land use boards, where there's a vote at a meeting to grant or deny some application. And someone then needs to go and sort of write up that decision. And this used to be easier until the legislature adopted the legislation that came into effect, I think it was towards the end of last year, that now requires all boards to make findings of fact when they are making decisions, land use boards. So writing decisions has become a more substantive thing. So what a lot of boards are doing is either the staff person or one member of the board are sort of writing up the decision after the vote has been taken. It then gets circulated to the board for everyone to review. That's not a meeting. If you hit reply and start having a conversation about that draft, that's a meeting. But just simply distributing that draft is not a meeting. And that's completely appropriate. You would distribute the drafts and people would come to the next properly noticed meeting to discuss any changes or concerns they have about the decision. So those are things that aren't meetings. When we have meetings, they have to be open to the public, and there can't be any votes by secret ballot. And any person is permitted to record those meetings, either by tape recorder or camera or video recording. And that can seem sometimes obtrusive and sometimes aggressive, and it can often feel a little bit like you're being bullied. And sometimes you are. But I think it's important to remember they have every right to be there. And the best thing you can do is just not make a big deal about it. Let them make the recording. And just, be conscious of the fact that you're being recorded. And maybe think twice before you say something that you might say in a less formal setting, or in a setting that's not being recorded. Of course, you have to keep minutes of all of your meetings as well. And this includes non-public sessions. And those minutes have to include the names of the members, all persons who appear before the public body. And that appear word isn't really defined. Some boards have people who attend, sign in, and we get all their names, and that's included in the minutes, and that's fine. Some boards only include the names of people who have spoken at the meeting, and I think that's fine. I prefer the method where people who are attending sign in, and we've got all their names in there, just because it seems to me that if you're attending, you're appearing. There's no court decision on this yet, and I don't think that the court would hold that you actually have to do that, but I think it's the better practice. In addition to the members, the names of the people who are there, you also have to do a brief description of the subject matter discussed in any final decisions. And this can go from one extreme of someone basically preparing a transcript to the other extreme, and I like to use my town of Hanover as an example because their zoning board has decided that someone needs to decide what's important at a meeting, and it's not the person taking notes. So the person taking minutes literally puts in the names of the people who are there and says they spoke about the application, and that's it. Now, for the Hanover Zoning Board, that tends to be fine because they do very, very detailed written decisions. But sometimes, on particularly contentious cases, we end up having to have those meetings transcribed. So there's a happy medium in there somewhere. And your minutes, generally speaking, are very good. They give me enough information without too much detail. And the reason those minutes are important outside the right to know law is because, particularly for our planning board and our zoning board, if we have to go to court to defend your decisions, those minutes are among the documents the court gets to review when deciding whether or not you have made the correct decision. There's no trial in those cases. It's purely based on the record. So that's why the minutes are so important for those boards. Minutes have to be open for inspection not more than 5 business days after the meeting, and they become permanent records of the town. Now, those minutes that have to be made available are obviously not going to be your final minutes, right? They're your draft minutes, and they can say draft on them, and they can say subject to changes by the board at its next meeting. Because most boards at their next meeting will go ahead and approve those draft minutes, some with changes, some just the way it is. There's actually no requirement in the law that you do that, but we all do it. So make sure those draft minutes are available for inspection within 5 business days. You can always edit them if you need to. And remember, the minutes are yours. We all know those people who like to come in and say, the minutes should say this, 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 and this, or I said this, or I meant this, and you put down that. The minutes are the board's. So you have them be what the board wants them to be, and no one from the outside gets to come in and tell you you're doing it right, wrong, or indifferent. It's up to you. Now, if you have an internet website, which you do, you either have to post the approved minutes in a consistent and reasonably accessible location on the website, or post and maintain a notice on the website stating where the minutes can be reviewed and where copies can be requested. So that came into play maybe 5 years ago. So that's something we need to start doing. For non-land use board meetings, which have their own special notice requirements if we're having hearings, for just a regular meeting, the requirement is that you post notice at least 24 hours ahead of time. And that literally means 24 hours. You could post notice right now for a 7 p.m. meeting tomorrow. 24 hours notice. It needs to be in 2 places, one of which may be the website, or it has to be printed in a newspaper of general circulation at least 24 hours before the meeting. Again, since you have a website, you can choose to post meeting notices on that website. And if you do that, you have to do it in a consistent and reasonably accessible location. And if you don't do it, you have to post a notice on the website of where the notices of the meetings can be found and reviewed. Now, this 24 hours notice doesn't apply in the case of an emergency. And an emergency is something that the chairman decides whether or not that exists or not. And it means a situation where immediate, undelayed action is deemed to be imperative. And so you're looking at things like we've had a flood and a road has washed out, or we've had a terrorist attack, or we've had a shooting in town, something that needs to be dealt with immediately. And in that case, you can have a meeting on less than 24 hours notice. You have to post a notice of the time and place of the meeting as soon as you can, give as much notice as you can, and employ whatever further means are necessary to reasonably inform the public that a meeting is being held. Put it on the website. If you do blasts on cell phones, send out a blast on the cell phone. You need to make every effort possible for the public to know that that meeting is going to occur. And the minutes of that meeting have to identify what the emergency was and why we couldn't wait 24 hours to address the problem. Now, if any member of the board, commission, committee, whatever you're sitting on, thinks that any discussion is happening in violation of the right to know law, either because the meeting hasn't been posted, or it wasn't posted 24 hours ahead of time, or you don't think there's an emergency, or you don't think there's a reason to go into non-public session, you can object to that discussion. And if the public body continues that discussion despite your objection, and if your objection is noted in the minutes, and it has to be noted in the minutes if you ask, then you can continue to participate in that discussion without fear of being subjected to the penalties that we're going to get to at the end of this talk. So if you're sitting there going, this isn't right because this should be in public, not in non-public, it's really important that you say that. And it's important not just so you aren't subject to the penalties, but so that your other board members can stop and think and make that decision, that affirmative decision that, you know, I think you're wrong. I think we're properly in non-public session, or you have a point. Maybe we should come out of non-public session. Maybe we should wait 24 hours, things like that. So objections are really, really important. Now, since we're on Zoom, this is an apt time to talk about participation in meetings by electronic or other means. These days, thanks to COVID, we're all pretty Zoom literate, but this can also be a speakerphone or some other platform by which someone who can't physically be at the meeting participates. You can allow that. You don't have to allow it. And I suggest you put it in your rules of procedure whether or not it's allowed. So someone who wants to participate electronically, there's got to be a reason why their physical attendance is not reasonably practical. They're in Florida. They're sick. There's a blizzard. It's not that it's raining and it's cold and I just don't feel like going out. That's not a basis to participate by electronic means. And the reason that that person isn't there has to be stated in the minutes. Now, again, except in an emergency, you still have to have a quorum of the body physically present. So you've properly noticed a meeting, a time, place, and date. You've got 3 members of the board there. You've got a 4th person participating electronically. Totally fine. That person counts as a full member, and all their votes count towards all your votes. It's important to remember that while you're doing this, everyone in the public who's there has to be able to hear what's being said, and the person on the phone and the board needs to be able to communicate contemporaneously. So you can't participate by email or by IM or by text, right? You've actually got to be on some sort of device where everyone in the room can hear what you're saying. Anyone who is participating electronically has to identify anyone else in the room with them wherever they are. I don't fully understand why that is. It makes sense on a non-public meeting. On a public meeting, I don't know why we have to do that, but we have to do that. And it does go on to specifically say no meeting shall be conducted by electronic mail or any other form of communication that does not permit the public to hear, read, or otherwise discern the meeting discussion contemporaneously. Communications outside a meeting are not permitted. That's 91A2A. And it says very clearly that you have to deliberate on matters over which you have jurisdiction only in meetings held pursuant to and in compliance with the law, and that communications outside a meeting, including sequential communications among members of the body, emails or texts, may not be used to circumvent the spirit or purpose of the law. So email, phone, having coffee, car rides, you just have to be very, very careful if there's a quorum of you, what you're talking about, and that you're not talking about business. Now, I keep talking about what you have to do as a quorum because the right to know law only applies to a quorum of the board. So technically, if you have a 5-member board and 2 of you are chatting, you're not in violation of the right to know law. That doesn't mean you're not in violation of some other law, because particularly, again, our land use boards, you sit in a quasi-judicial capacity. And so you need to be unbiased and go into your decisions without any sort of prejudgment or extra communications outside the meeting. So right to know law applies to a quorum, but if you have one member of the board talking to all other members of the board to come up with a decision, even if they're not all in the same room, a court's not going to like it. And if you're on a quasi-judicial board and there's two of you, you're going to have problems beyond the right to know law. Now, I think most of us know there's also the option for boards to go into what some boards call executive session, what the law calls a non-public session. But non-public sessions are rare, should be rare, and are only permitted in certain circumstances. And those circumstances are spelled out in RSA 91A3. And before we talk about what those circumstances are, let's talk about how we go into a non-public session. To go into a non-public session, you have to convene a public meeting. And then someone has to make a motion to go into non-public session. When you make that motion, you have to identify the section of the statute under which you're going into non-public session. And there has to be a roll call vote of the board to decide whether or not to go into that non-public session. Once you're in that non-public session, you can only talk about whatever you said you were going into non-public session about. So if you say you're going into non-public session to discuss hiring an employee, and while you're in there, someone says, oh gosh, while we're here, I have this other thing to talk about under the reputation exemption. You can't talk about that. You have to come back out of non-public, make another motion to go in under the reputation exception, and then go back in. You can, if you know ahead of time that there's going to be 2 or 3 topics you need to discuss, say we're going into non-public session under this section, and this section, that's fine. But once you're there, you have to make sure what you're talking about was whatever the exception you cited at the beginning. So here is what we can talk about in non-public session. The first is the dismissal, promotion, or compensation of any public employee, or the disciplining of any public employee, or the investigation into any public employee, unless that employee has a right to a meeting and requests that the meeting be open, in which case it has to be open. To use this exception, you have to let the employee know you are going into non-public session to talk about them, because they have to be able to exercise their right to choose to have it in an open session. So pre-notice to whoever we're talking about in terms of employment. You can also go into non-public session to talk about hiring a public employee. Often, if you have applications for posts, it's coming from people who are probably employed by another town and would probably prefer that that other town not necessarily know that they're applying for a job elsewhere. You're allowed to do that in non-public session. You can also talk about matters which, if discussed in public, would likely adversely affect the reputation of any person other than a member of the board itself, unless that person requests an open meeting. Now, interestingly, to use this exception, you don't have to tell the person you're going to go in and talk about them. There was a recent case, and the court didn't have any problem with the fact that people weren't getting notice about this, because unlike in the employment context, there's no life interest in it, right? If you're going to be fired or disciplined from your job, you have a pecuniary interest in that decision. If they're just going to talk about you in what might not be a flattering way, you don't have that same level of interest. You can also go into non-public session to talk about the acquisition, sale, or lease of property, which, if it was discussed in public, would likely benefit a party or parties whose interests are adverse to those of the general community. Some towns interpret this to mean anytime they're going to buy real estate or sell real estate, they can go into non-public session. That's not true. If you are being offered a property at a sweetheart deal because the person who's selling it really wants to sell it to the town, you can talk about that in non-public session. If you're talking to someone before the property goes on the open market, you can talk about that in non-public session. But if everyone knows you're going to buy the property down the street to build a new town hall, and everybody knows the fair market value of that property, and everybody knows you're going to pay the fair market value, that gets discussed in public. You can also discuss consideration or negotiation of pending claims or litigation which has been threatened in writing or filed by or against the town. So when you're being sued and the lawyer sends you an email and says, hey, would you like to pursue this strategy or that strategy? You can talk about that in non-public session. Normally, the lawyer's probably going to be there in one form or another, but even if they're not, you can have that conversation. You can also go into non-public session to talk about emergency functions, specifically those to thwart terrorism. And you can go into non-public session to consider legal advice that was provided by counsel ahead of time, even if counsel's not there. And you can go into non-public session to discuss whether or not to release minutes of non-public sessions, which makes some measure of sense. Any vote to disclose those minutes has to be done in public. And with the real estate exemption, as soon as that transaction is closed, those minutes need to be released to the public. Minutes of non-public sessions, if they're not sealed, have to be disclosed within 72 hours. But going back to what minutes need to include, they can be incredibly brief, right? We went into non-public session. Here are the members who were there. This was the roll call vote. We went in to discuss hiring a new Parks and Rec director. No decisions were made. We came out of non-public session. Perfectly legal non-public session minutes. And as a general rule, I encourage you to have those kind of minutes because then you don't have to worry about sealing them or releasing them or anything about them. Sometimes you can't do it that tersely. Sometimes you really need the record of what was discussed and what decisions were made. And in that case, that's fine. You make those decisions, you make that record, and you seal those minutes. And we're going to talk about unsealing those minutes in a few. To seal the minutes, you need a vote of 2/3 of all the members, and that vote actually has to be taken in public. So what I like to recommend is that there's a motion to seal the minutes both in non-public and in public, so that anyone looking at the non-public minutes alone can see that it was sealed. Because otherwise, if you get a set of non-public minutes and you don't get the public minutes as well, you don't always know that. So I recommend 2 votes to seal the minutes. Now, minutes can only be sealed if divulgence of the information in those minutes would likely adversely affect the reputation of anyone who's not on the board or render the proposed action ineffective, it's the real estate one, or pertain to terrorism. And they stay sealed until the board decides that there's not a reason to keep them sealed anymore. The real estate transaction one is very easy to decide when it's time to unseal them. The reputation one can be harder. The employment one can be even harder. So what the statute now requires is that for all of your sealed minutes, you keep a list of them. And that list has to identify the board, the date and time of the meeting that was held in non-public session, the specific exemption that the non-public session was held pursuant to, and the date of the decision to withhold the minutes from public disclosure, as well as the date of any subsequent decisions to either keep those minutes sealed or disclose those minutes. And that list has to be publicly available. So the legislature adopted that provision a year or 2 ago. And I don't know what happened, but clearly they weren't happy with how towns were processing it, because then this year they went ahead and adopted another provision, part of which makes sense. So what it says is that the public body may adopt procedures to review minutes of meetings held in non-public session and determine by a majority vote whether or not the circumstances are justified to keep them sealed. Okay. But then it goes on to say that if you don't do that, you still have to go back and review your non-public minutes periodically and decide whether there's a reason to keep them sealed. And that has to be done at a minimum of every 10 years. And anything that was sealed prior to the adoption of this amendment automatically becomes public in 10 years if you don't review them and decide you need to keep them sealed. So I don't really know what kind of procedure the legislature had in mind, unless that was maybe delegating to a staff member. You know, you can go through the non-public minutes, and if it relates to this, or this, unseal them. But I would say yearly it would be a good idea to have a non-public session, go into non-public session, discuss all the minutes that have been sealed, and determine whether or not there is still a basis to keep them sealed. And whether or not there's a basis to keep them sealed is an objective standard. So it doesn't matter that the board members have changed. It doesn't matter that a former board member might have said something in that session that they'd prefer the world not know about. It is the town that is responsible for the sealing and the town that is responsible for the unsealing. And the town, who the town is, changes periodically. But we all have the obligation to continue to review those minutes and make sure we're unsealing them in a timely manner. So that is really the gist of the meeting section. Does anyone have questions about that before we move on to documents? From Eileen, I have a question about the process of unsealing. Oh, where'd you go?
Hi there.
Hi, go ahead, Eileen.
So in terms of how that works and operationalizing that, does there have to be can one party, one board member, one committee member go in and do it on their own? Or does there have to be a vote in public that that's going to happen? Everyone be aware that a board member is going to go in and review those sealed minutes, identify the meeting minutes that they are reviewing, and somehow report that process out formally?
So I would say no one board member has the right to go in and review the sealed minutes unless that is the procedure the board has adopted as a board in public. So like we talked about, maybe you want to delegate to one board member. You go in, you review all the sealed minutes, and you let us know what you think needs to be unsealed or not. There doesn't need to be any notice that that one member is going in to do that. But when that member reports back to the board in non-public session, you have to keep minutes, and any vote to unseal those minutes has to be done in public. Does that answer your question?
I think so. I think so a board would enter into non-public to discuss what was reviewed, and then anything that's going to be unsealed would be discussed back in public.
Yes.
That these minutes are being unsealed. So there would have to be a formal process that the board or committee undertook. Okay.
Yes.
Thank you.
You're welcome. Andy, I saw you turn your camera on. Does that mean you have a question?
Yes, I do. And sorry for my tardiness. I did have to pick up a daughter at the airport today and couldn't negotiate around that one. But my question is, it might be more for Naomi and for Eileen, but where are those sealed minutes supposed to be kept? Is there any guidance on, where they reside within the structure of a town?
They should be with the town clerk. They should be literally in a sealed envelope and they should have the date of the meeting, and they should have the exception on it, and they should have the board name. And then those are kept essentially in the same place as the regular minutes, but they are literally each in their own sealed envelope.
Thank you.
You're welcome. Any other questions before we move on? Yeah, Jack.
Yes, we rarely go into non-public.
Yeah.
But if we got a letter from the attorney on a case and we wanted to go in there.
Yep.
We can read it. We'll basically say, going into it, we'll say something to the effect of receiving legal counsel's response to a question, right?
Yep. Yep.
We go in there, we can only discuss that.
Yep.
The minutes would show something to the effect that we discussed this, but we don't take a vote. We just want the information.
Yep.
So we basically say we didn't take a vote.
Yep.
Are we required to seal that because it is? Okay. So in other words, I get it. I just want to make sure that we don't have to seal by virtue of sealing. Even an attorney's position would require us to divulge it in the future. But if we don't,
no. So
okay,
I would say those minutes should be exactly what you just said. Discussed advice from attorney. You can put in the topic if you want. No decisions are made. That's all the minutes need to say, and there's no reason to seal those. And that doesn't waive the privilege on the advice you're discussing, which I think is what you were asking.
Right. Is there
Yeah.
any other imaginable case why we would go into a land use board would go into non-public, other than
Yeah.
I can't think of either.
I have a really hard time envisioning a situation where a land use board would go into non-public session outside of legal advice of counsel.
Perfect, thanks.
You're welcome.
And
Any other
we've only done that on our purchases before we
The
get
real
the purchase
estate.
and sale
Yeah.
set. Typically, once we have the purchase and sale set, the discussions are public because we have a binding agreement with both parties at that point.
Exactly. And you would go back and unseal any minutes that you had sealed.
Yes, I can't say we have every time, but yes, understood.
We
that
will going
we
forward.
need to. Yes.
Okay. Any other questions before we move on? Naomi.
So, NHMA had their conference and we listened to Cordell, and I understand that they do with the town clerk. They're basically generated from us, but I'm not breaking a law if I don't run them downstairs within a few minutes. If they stay in a law cabinet in our room, I guess my thought being that, and we have not looked at sealed minutes for a long time. Actually, they go back way longer than I've been sitting in this seat, and since 2009. So if we're going to make a habit, policy, or whatever to look at them every year, then is it, if we keep the list that's available to the public, is it against the rules to have them in my office in a sealed one, so I don't have to make sure and get them out of the vault before going to a meeting,
Right.
as long as we share the list? Is that against the law?
So the only reason I said they should be on file with the town clerk is because technically that's where all your minutes are supposed to be. So it makes sense that your non-public minutes would be there too. I think if they were kept in a sealed drawer in the town administrator's office or in the selectman's office, I think that would be fine, as long as that list is publicly available down at the town clerk's office.
Yeah, because I generate the list and then I typically will bring the envelope down. But if we want to be more proactive with not having this boxes of sealed minutes that God only knows what they say,
Yep.
then it would behoove us to not even wait a year if I could hang on to them for a few months, because I still can't wrap my head around, honestly, what might be in some minutes that I know it doesn't matter, but if you're not a sitting board member anymore, and what if somebody did do them detailed and we unseal them, and could someone go after a former member if it was detailed enough that said, a former member said this? I'm just,
As a general rule, when we say things in meetings in our role as a board member, we're pretty much exempt from defamation lawsuits or slander lawsuits. I'm not going to say it's an absolute privilege, but there is a privilege for saying things in the course of doing your job as a board member. So I don't worry about that. And I know there's been a question, at least in town, about, well, no one ever reviews the non-public minutes before they're sealed, so we don't know what's in them.
Right.
So this is why we review them, right? And if we review them and it turns out that 98% of it can be released and 1% needs to be redacted, we can just redact that 1% and keep that sealed for whatever reason. If people were less than discreet in keeping the minutes, there's not a whole lot we can do about that. But I don't worry about there being any sort of retribution against the board members.
yeah. So let me follow one more, and I'm sorry, so if a former member wants, says, I would like my name redacted in anything I said in any non-public minutes, because they're not going to be able to look at it. Can those non-public minutes, because you haven't really even looked at them, they're really notes, can the request and the board redact what's there? Okay.
No, not unless it's otherwise sealable.
Okay. No, fair enough. Thank you.
You're welcome. Anyone else? Okay, let's move on to the tantalizing subject of minutes and records being available for public inspection. So the law requires that all of your minutes, all of your records, all of your documents that the board is required to keep be kept at the town office. And RSA 33A is the Municipal Retention Act, and it will tell you exactly how long you have to keep everything. But they need to be at the town office because they need to be available for the public to come review. Any citizen has the right to inspect any governmental record in the possession, custody, or control of the public body, including minutes of meetings of the public bodies, and also to copy or make memorandum or abstract of those records or minutes so inspected. So the reason I'm talking in detail about this is because I know sometimes there's a situation where boards engage consultants and those consultants keep those records. That's not in compliance with the right to know law. All of those records need to be kept by the town at the town office. The consultant can keep copies, but we need to have them at the town offices. Now, you have to make them available for inspection. But no one ever writes you a letter and says, hey, I'd like to come in and inspect these records. People say, hey, can you make copies of the minutes for the past 100 years and send them to me? And you should feel free to say, no, I am happy to make those records available for you to come in and inspect. And you can take pictures of them and you can identify specific ones that you want copies of, and I will make you copies of them. But I'm not just going to stand here in front of the copier all day long and make you copies of 100 years of records. When I was a very young lawyer, I needed to go to the Attorney General's office to review a lot of records. They wouldn't even make a copier available for us. We actually had to rent a copier and take it with us to make copies of the records. I wouldn't suggest going that far, but I will say I think that was completely legal of them. So you have the obligation to make it inspected. You don't have the obligation to necessarily copy them. So then there's some specific records that have to be on file in a specific place for a specific amount of time. So if you have an employee leave your employment, they resign, they're fired, they retire, and you pay them anything beyond their regular salary and their accrued vacation, sick, or other leave, you have to have a record of that payment immediately available without alteration for public inspection. And that needs to be, again, with the town clerk. After the completion of a meeting, not only do citizens have a right to review the minutes of that meeting, but if there were notes or tapes or other sources used to make those minutes, they get those as well. Now, here's the nuance on that. The Municipal Records Act doesn't require you to keep those materials. It is perfectly fine to destroy them once the minutes are approved. So if you have a policy of taping your meetings, using that tape to make minutes, approving those minutes, and then destroying and reusing, in the old days, destroying and reusing the tape, that's completely legal. But if that's going to be your policy, let's have a policy that says source materials will be destroyed after the minutes are approved. Because if they're not erased or destroyed, even though you don't have to keep them, people have every right to review them. And normally it's not a problem, right? You want the tape, you can have the tape. But for smaller towns that actually have tapes, sometimes that's a harder thing. I know in Weare most things get sent out on the internet. You can probably just send a link. Any government record that is created or maintained in electronic form has to be kept and maintained for the same retention period as is set forth in 33A. And a document is no longer subject to disclosure when it's deleted. Now, deleted doesn't mean you hit the delete box and it's sitting in your deleted file. It has to be deleted so that there is no conceivable way to access it. There was a recent case out of the city of Nashua where someone had asked for emails between a former employee and other people. And because that employee had left the employment of the city, their email account was deleted. And that was fine until they went to trial and their IT person said, well, yeah, it's deleted, but I mean, I can find it. I do it all the time. It takes a couple hours. Well, the city of Nashua had to produce those emails and had to pay some penalties, like the attorney's fees of the other side. So deleted means deleted, not just not convenient to get right now. If someone comes in and they ask for a record and you have it immediately available, you have to make it immediately available. If for some reason it's not immediately available, you have 5 days to respond. And your responses can be one of 3 things. You can produce the document, you can refuse to produce the document and tell them why you're refusing to produce the document, or you can say you're looking for records for the past 100 years. It's going to take us a while. In fact, it's going to take us at least 60 days. And at the end of those 60 days, if you still haven't been able to compile all those records, you write them again. You say, I'm working on it. Here's what I've got so far. Come on in and inspect those, and I'll continue to work on the rest of it. So you have the right to take more than 5 days if it's necessary to reasonably respond to the request. But within those 5 days, you do have to acknowledge that request and tell them how long it's going to take. If you do supply copies, if that's done either through photocopies or downloading onto a stick drive, it's sometimes done, you get to charge them for the copy, and you get to charge the reasonable cost of the copy. So that doesn't just mean the cost of the paper, right? There was another case out of Nashua a few years ago that talked about included in this cost can be the cost of leasing the copier, the cost of the toner, the cost of the paper. What it cannot include is the cost of the time of either finding that record or making that copy. That is an expense of the town, and you have to absorb that expense. You may not charge for the time incurred in responding to these requests, no matter how duplicative, how annoying, how outrageous, and how irrelevant they may be. Ray has just asked a question about deleting electronic data. That is nearly impossible without erasing the entire drive. Yeah, it is, which means you've got to find the document that's being requested, and you've got to produce it. And sometimes that requires us to call our IT people and say, hey, we need to find this, and it was deleted. Can you go search the nether regions of wherever you search and see if you can find it? And you have to make a reasonable search, right? You don't have to make a god-awful exhaustive search. You have to make a reasonable search. So if they're asking for an email from 10 years ago, which obviously no one would have on their computers, you would call them, you'd say, I have this request. Is there a way for you to search for this document? If there is, great, you have to do it. If there's not, then that's your response to the right to know request, right? This is from 10 years ago. It's been permanently deleted. We have no way to access it. Done. And as long as your IT guy doesn't go into court and sandbag you, you'll be fine.
Well, so my question is more if I go in and delete a record, it deletes the pointer to it. From a forensics perspective, that could still be extracted.
Yeah.
But it would take a lot of work, right? And there would be a cost associated with it, right?
Yes.
Typically, the only way to ensure a data is totally gone is to write ones and zeros over the drive 6 or 7 times.
Yeah. Yeah. And, it's going to depend on the requester, right? If you have a reasonable requester and you say it's deleted, we don't have any reasonable way to access it, 90% of the people are going to take it. Those people don't live in Weare. The people who live in Weare are going to say, well, go find it. And there's a Superior Court case from about 20 years ago that says if you have to do something like that, if you have to engage an outside party to go search for these records, you can charge the requester for that, just like you could charge them for making the copy, because that is an additional expense. That is not just normal town expense. So it's going to depend on who the requester is. It's going to depend on what's being requested. And to some extent, it's going to depend on how much digging it would actually take to get that record. Does that make sense?
Well, it does. And being a tech guy, right? Because if I really wanted to go after Weare or whatever, which I don't, love Weare, right? But if the data was there and I said, okay, I want you to go after it, that means that drive would have to go to a forensics, and the town of Weare would be impacted by the fact that now I'm taking a drive with other data out. It's probably way more of a complicated question, but it's interesting that that law would be written in that way, which kind of fascinates me a little bit.
Well, we love our legislators, right? But they don't necessarily understand what they're requiring towns to do when they pass these things. It sounds great, right?
Yeah.
Deleted doesn't just mean in the deleted file, it means deleted. But when the law was written, deleted didn't mean the same thing as it does now. So that might be something that needs to be updated. While we're talking about this, yeah, go ahead, Naomi.
So what we're doing, and I just want the right thing is we don't have the funds to do it, but we're going to move forward. I think, Laura, just at ease, is the board members are going to have town emails, and we'll pay per month. But I think is that will make our gathering information off our server with our IT guy for everybody that way, provided they use their town issued emails, correct?
That is the perfect segue into what I was going to say, which is, for the love of God, set up a separate email address for whatever you're doing for the town. Because if someone says, I want emails between Benji and Naomi email from their personal email addresses, congratulations, you've just sent your entire computer to the forensic people to be analyzed for those emails. So yes, town email addresses are great. If you don't have a formal town email address, set one up. Do it, set up a Google address, set up a Yahoo address, set up whatever kind of address you want that you only use for town business. That is going to be the best way to protect your personal computer and your personal data from having to be disclosed. While we're at it, don't text, because I've had a situation where there was a request for texts, had to have the IT people come in and download them all. It was a nightmare. There's no reason for you to be texting outside a meeting. There's little reason for you to be emailing outside a meeting. The best thing you can do is pick up the phone and call someone, as long as it's not, a meeting. So if you keep things in electronic format, you have the option to provide them to the requester in that electronic format. Or if that's not practical, or if the person asks for the printout, you can give them the printout. Every agreement to settle a lawsuit against the town, or a threatened lawsuit, or any other claim against the town that is settled by the town or its insurance carrier has to be kept on file at the clerk's office and made available for public inspection for 10 years. So keep that in mind. And the other really important thing to keep in mind is that nothing in 91A requires the town to compile, cross-reference, or assemble information into a form in which it is not already kept. You don't have to answer questions. You don't have to put together tables. You don't have to do anything other than produce what you have. Now, sometimes it's a lot easier to answer the question than to produce the documents that would answer the question. And in that case, if you answer the question and that makes the requester happy, fabulous. But if you get a question, you don't have to answer it. But if you get that question and you have responsive documents, you have to produce them. So it's not as easy as, oh, they're asking a question, we can just say no. You have to analyze the questions being asked and determine whether or not there are documents. Naomi, you look like you were going to ask something else. No? Okay. Now, there are exemptions, just like there's non-public sessions. Go ahead, Andy.
Okay, so can an outside party request all communications between two individuals? Because that doesn't involve a quorum. How does the issue of town activity and the quorum standard apply to that example of, say, Benji and Naomi are talking about something over email? We want all the records.
Yeah. So the statute defines a governmental record as any information created, accepted, or obtained by or on behalf of the board or quorum of the board or any public agency in furtherance of its official function. It includes written communications or other information, whether paper, electronic, or other physical form, received by a quorum or a majority of the board in furtherance of the official government function. There is not any case law directly on point, but there's enough case law on this general issue of emails that I can tell you a court is going to hold if two members of the board are emailing each other about substantive issues that the board has jurisdiction, control, or supervision over, the court's going to make you disclose those emails, whether or not they're distributed to a quorum. And I can make the argument that you don't have to disclose them if they're not circulated to a quorum. I don't think we're going to win, and you would be the test case. So a policy decision becomes, do you want to become the test case? Or
No,
you just
thank
want
you.
to turn over the emails?
Not at all. So that's where your input is so much more valuable than just trying to read a statute and think you know what it
Yeah.
says.
Yeah,
Thank you.
because we come back to the preamble, right? Openness in government and not taking actions to circumvent the law. So I think the Supreme Court, particularly this Supreme Court, is going to make you disclose those.
Thank you.
You're welcome. So certain things don't have to be disclosed. And this is a topic that has gotten a lot of Supreme Court treatment lately. You don't have to disclose things relating to internal personnel practices, confidential documents, documents about library users, or any other file who would disclose that the disclosure would constitute an invasion of privacy. Think of this in terms of someone writes to the town and says, I want to know what health insurance plan all the town employees are on. Seems like an innocuous question, right? But whether you're on a single person health plan, a couple health plan, or a family plan, discloses a lot of information about you and could constitute an invasion of privacy. So if you were to get that request, I would say feel free to tell them these are the people who are on our town healthcare, but be cautious about how much information you're giving out about which health plan they're on, because you want to be careful not to constitute an invasion of privacy. Now, let me say, all of these exceptions are things that you can withhold. You can go into non-public session. There is nothing in the law that requires you to go into non-public session or withhold these documents. The people who these documents are about or you're talking about are going to scream up and down, you have to go into non-public session. It was illegal to talk about this in public. No, those are options for the town. They don't give a rise of action to someone who thinks you violated the law by being too open. Okay. You can also withhold documents relating to emergency functions, again, terrorism. Any notes or other materials made for personal use. So if I'm sitting on a board and I'm taking notes as someone's talking and I'm using that to inform my vote, that doesn't have to become a public record. That's just for me. Again, preliminary drafts that are not circulated to a quorum don't have to be disclosed. There's an exception for certain body-worn camera, police body-worn camera footage. Some of it doesn't have to be disclosed, but a lot of it does. The exceptions sort of swallow the rule in that one. You don't have to provide information about your information technology system, which makes sense. You don't have to provide attorney-client privilege documents. And attorney-client privilege documents are interesting because sometimes a town board will read all or a part of an email that the attorney has provided. That still doesn't require the disclosure of the document. I mean, if you've read the whole thing in public, there's really no reason to not disclose it, but you don't have to disclose it. So keep that in mind. That is what I have to say about documents. We're going to move on to violations and remedies. So does anyone have any other questions about documents? No?
It sounds like the short of it is, if you have it, give it up.
There's really, I mean, right to, especially as we talk about the violations and the remedies, it is always better to say, here, take it. Because what are you hiding, right?
Right.
I mean, some people are jerks and you just want to say you're a jerk and I'm not going to give it to you. And that's a completely human reaction. But I think in that situation, the better course of action is, you're a jerk. Here are all the documents for you to come in and inspect, but you're going to have to come in and inspect them. And you're not going to find anything that's going to, you know, make your day, because we haven't done anything wrong. So that is always going to be my first instinct, and the court's first instinct is disclose it.
Thank you.
You're welcome. So in 2022, the legislature adopted what's called the Right to Know Law Ombudsman. So normally when there's a violation of the right to know law, you file a petition with the Superior Court. But the legislature likes to create these sort of specialized agencies, right? We have the Board of Tax and Land Appeals that can handle exemptions and tax abatements. We have the Housing Appeals Board now that handles appeals of decisions of zoning and planning boards that have to do with housing. So they thought, well, why not create the Office of the Right to Know Law Ombudsman? So this one person can review these issues really quickly. They can review whatever people are fighting about. They can make a decision quicker than the courts can. Which apparently they thought was a good idea, but not a great idea, because while they adopted it, it all expires in 2025, unless it's renewed. I have not had any personal experience in front of the Right to Know Law Ombudsman. I know he has not yet adopted rules, and he's been around for a year. And I don't know whether that's him not adopting rules or the rules not being approved. And I don't know how busy he is or what his inclinations are in terms of this. But that is out there. Doesn't really affect anything other than it's a different forum that you can go to. So you have to file a petition with either the Superior Court or the Right to Know Law Ombudsman. And it has to state how the town allegedly violated the right to know law. If the court finds that you did, here's where the rubber sort of meets the road, because the remedies can be pretty onerous. If the court finds that the lawsuit was necessary for the disclosure of the documents, and that the public body knew or reasonably should have known that the conduct engaged in was a violation of the chapter, it can award the other side its attorney's fees. And those add up really quickly, because the lawyers who do this litigation are very specialized, they're very experienced, and they're very expensive. Again, I refer you to the Nashua case. It was a huge amount of attorney's fees. I had a situation in Sandwich a few years ago. It was over $200,000 in attorney's fees that were awarded. I mean, it really does rack up pretty quickly. So that is the first sort of Damocles hanging over you. Now, if you are being forced to defend against a right to know lawsuit that is in bad faith, frivolous, unjust, vexatious, wanton, or oppressive, the court may award you your attorney's fees in having to defend that lawsuit. That's sort of the standard for when you can request your attorney's fees, right? It's either authorized by the statute, or you've agreed to it, or it's just a really frivolous lawsuit. So if one of these lawsuits is just really frivolous, you may get your attorney's fees awarded to you. The court can invalidate any action that a board takes at an illegal meeting. And this is why often when I get the call that says, I think we had an illegal meeting last night, and I just say, okay, well, we can't undo that, but here's what you can do. You can notice and hold a new meeting, and at that new meeting, you can have this discussion again, and you can take this vote again, and you can cure the problem. And honestly, if you do that, even if you get sued, the court's going to realize, all right, you knew there was a problem, you called the lawyer, you did everything you could to fix the problem. I'm not going to award attorney's fees against you. I'm not going to invalidate your action because you fixed it. Now, if a court finds that any individual board member or employee violates the law in bad faith, it can award civil penalties against the individual member between $250 and $2,000. And those civil penalties get paid to the town. And if the town is required to reimburse the requesting party their attorney's fees, the individual board member or employee can be liable to the town for that cost. So this is why I really beat the drum on the right to know law and disclose, because if a court finds you screwed up, there are some really, really severe penalties. And of course, it can also send you for remedial training, which frankly, we could all use from time to time, but it can be a bit of a pain in the butt to have to schedule. One other possible consequence is if you are found to have knowingly destroyed information with the purpose of preventing that information from being inspected or disclosed, it is a misdemeanor. And that portion of the statute goes on to say, if a request for inspection is denied on the grounds that the information is exempt under the chapter, that material has to be preserved for at least 90 days or as long as the lawsuit is pending. So don't deny a request and then destroy the documents that you denied. Just hold on to them. You probably have to hold under them under the Municipal Records Act anyway. So that is a very, very quick summary of the right to know law. It was very dense. What I have done is I have taken the statute and I've sort of condensed it and made it a little more readable, and I will send that to Naomi for distribution. If any of you have questions after tonight, you know, if you're trying to fall asleep and something pops into your head, call Naomi. She'll send me the question. I will answer it for you. I'm always happy to talk to you about right to know requests or meeting requests. It is always cheaper to call us before the problem arises. And so I'm here to help. I know sometimes it feels like I'm not on your side. I'm always on your side. I just want to make sure we're complying with the law.
So I have a question.
Yeah.
So can you go back at the beginning, you talked about a non-meeting.
Yep.
So we meet collective bargain wise, and at some point we have to, as a board, talk about what we're going to do with, you know, we've kind of made a tentative agreement, but we still need to talk about it as a board, but we don't have town council there. Is that still a non-meeting?
Yes.
So even
The way
though
I read it, it is. It's a strategy or negotiations with respect to collective bargaining.
okay, because we wavered a little bit last night, and I just wanted to make sure we were on firm ground for the fact that there was a quorum of us. We didn't go into non-public, we did a non-meeting. And I just want to make sure, you know, it was basically to talk about our strategy to go back to the table.
Yeah,
And
I think that's fine.
right, because I don't want, as you know, our meetings get watched by many. So I just
do.
want to make sure we were on solid ground and don't have some surprise request. That's all.
You might get a request, but I think you're on solid ground.
Okay, thank you very much.
You're welcome.
Anyone else? Thank you, Lauren. We recorded it for anybody that didn't meet. Not everybody could make tonight. There's never a night that you're going to meet with everybody. So
Yeah.
I appreciate the time. And
Of course. And again, I apologize so profusely for being late.
That's right. And I was off today, so I didn't answer your email. So sorry. Tuesdays is not a good day for me.
Yeah.
Naomi, where's that recording going to be, or how are you going to distribute?
So this is the first time I recorded it. So I did a test run yesterday, and it will send me an email when it's ready and tells me it's ready. So I could distribute it. And like Laura had told me when I asked about recording it, that it also is available to anybody that all of a sudden wants to ask us about right to know what we talked about. So, you know, we may be sharing it with everybody at the same time, but I will, once I get Laura's information, I certainly can share the recording for those that couldn't make tonight, because I do know there's several that had emailed me and had prior commitments. So
where I think the question, Naomi, is where is it physically going to be posted?
well, right now it's going to the cloud, and I hope the cloud doesn't crash. So
yeah, because you won't be able to email it. It'll be way too big.
okay, well, I guess I'll have to come up with plan B, Ray, my little IT guy. I might have to ask a question.
Yeah, can we post it to the website?
I don't see why not, Laura. Could we, or? Okay.
Absolutely. Yep.
Okay,
Yep. This
That's
was done with the
fine.
idea that it might be public.
yeah, that's probably where it will go then.
Okay,
And I'll
that,
let
that'll
everybody
work.
know. Okay,
Sounds good. Thank you.
yeah, thank you guys for
Thank
all
you.
coming. Mark, you had any
Thank you,
questions?
everyone.
What's up, Naomi?
All right,
Nice to see you all.
yeah, thanks, Laura, very much.
Good night.
Good night,
Good
everyone.
night, all.
Good night.